And as I gave you an introduction during the last class of what is promissory estoppel, that is a promise once made cannot be retracted from. So what is promissory estoppel? If you look at the word promissory, there is a word promise that is included in that word, or it is encompassed in that word promissory. There is the word promise in the word promissory. And if you see estoppel, again, if you break that word, you can see the word stop right in between. Estoppel, stop. So that means you get two words here, promise and stop. So now connecting to the point of contract law, promissory estoppel means something related to a promise and something related to the word stop. If you try to apply contractual mind, one would draw a conclusion that the doctrine of promissory estoppel, in terms of contract law, would mean that a promise once made should not be broken. And in case it is broken, in simple words, I'm telling you, just in simple words, layman's language, and in case it is broken and it causes harm to another person to whom the promise was made, and if the promisee, that is a person to whom the promise is made, he or she acts upon the promise, and as a result of acting on the promise, there has been a particular harm that is caused to the person, then the law says that the promisor, that is the person who makes the promise, will not be allowed to move back from that promise. So that means the person is estopped from moving back or retracting from the promise. Therefore, within the law of contract, promissory estoppel refers to the doctrine that a party may recover on the basis of the promise made when the party's reliance on the promise was reasonable and the party attempting to recover detrimentally. That means there has been, to his detriment, or there has been a harm caused or detrimentally relied upon that promise. Are you understanding me? So basically, the requirements for promissory estoppel to operate, or the doctrine of promissory estoppel to operate, is that there has been a promise. Mute your mic, please. Always mute your mic. There has been a promise. First thing, there has been a clear and an unambiguous promise made by a person. A person who makes the promise is called the promisor. The person to whom the promise is made is called the promisee. So that means there has been a clear and an unambiguous promise proceeding from the promisor to the promisee. Then the promisee has acted in reliance on that promise. Then the promisee's reliance was reasonable and foreseeable. Why it is reasonable? Because the promisee depended upon the promise made by the promisor. Then the promisee, as a result of relying on that promise, has suffered an injury or has suffered some harm or has acted upon the promise to his or her detriment. Now, in certain jurisdictions like USA, there is an alternative term that is used for promissory estoppel. You can write it down. It is also called as doctrine of detrimental reliance. I repeat, it is also called as the doctrine of detrimental reliance. Detrimental. D-E-T-R-I-M-E-N-T-A-L. Detrimental reliance. R-E-L-I-A-N-C-E. Doctrine of detrimental reliance. So therefore, promissory estoppel is a legal doctrine that says parties may be liable for broken promises that might result in financial harm or any other contractual harm. Now let's go on through our slides to see what our slide says. What is the doctrine of promissory estoppel? Now, a promise made without consideration is not generally enforceable. Last class, we learned about consideration. We also said that past consideration is no consideration. However, there are exceptions to it. And you've also written your homework on that particular question. A past consideration is no consideration on the particular statement, and I asked you to explain that. Coming back to the doctrine of promissory estoppel, a promise made without consideration is not generally enforceable. So the doctrine of promissory estoppel is a principle in contract law that when a party promises another party something, the other party acts upon the promise, then the party making the promise is estopped from retracting, that is, moving back from that promise. To understand this further, we'll also see certain case laws and you will understand the concept. Again, reiterating, you've already written your assignment or you're in the process of writing this assignment. And also I, uploaded certain classroom sessions on your Google Classroom portal on this doctrine. So I'm sure you've gone through those particular video sessions and you might already understand what is promissory estoppel. So just to reinforce your understanding and to help you understand, we are going through this session and through this topic in this particular session. Now, what is estoppel again? Estoppel. Estoppel is a legal principle that cautions parties or that alerts parties to a contract from retracting or going back on their promise. Promissory estoppel buttresses or emphasizes the contractual principle that a promise can be enforced by the law if after relying on the promise, the promisee has acted upon the promise and that the promiser has retracted or gone back or moved back from the promise, causing consequent harm, injury, damage, or loss to the promisee. So this principle is rooted in the laws of equity. I'm repeating, this principle is rooted in the laws of equity. So this is, it draws its allegiance from the principle of equity or the laws of equity. So the promisor is estopped or prohibited from taking the stance that he did not intend to create a legally enforceable relationship, which further needs to be proved in the court of law. So this concept and its applicability, of course, it varies jurisdiction to jurisdiction, country to country. Now, talking about countries and jurisdiction, I asked you last class, what kind of jurisdiction does certain countries in Africa have? And I referred to the country of Somalia and asked you what kind of jurisdiction it is, whether it is a civil jurisdiction or a common law jurisdiction. So I'm sure by the end of this class, you're going to answer that question. Well, suppose you're not able to answer, of course, I'll give you the answer, but I gave it to you as
no. We have a civilian law.
Civil law.
Yes.
I will reply to
civil
that.
Law, yes.
Okay, good. I will reply to this end of the class. Okay. Thanks for answering. Okay. So now let's continue to the doctrine of promissory estoppel. Okay. So we spoke about the concept and now we will talk about a case law that is an Australian case law, Walton Stores Interstate Limited versus Mahir, 1988 case. This is a very interesting case. Now, what happens here in this case is Walton's, it was a particular company, they negotiated with a person called Mahir for the lease of a property owned by Mahir. So the parties understood that Mahir would demolish an existing building and erect a new one which Waltons would occupy. Now, what happened in this case? Let us go through the facts. These Waltons were actually a kind of a construction company, okay? And there was this guy called Mahir. He owned a particular property. So what happened was Waltons wanted to lease the property of Mahir. This is an Australian case. And in this particular case, the Australian High Court, they came up with a principle, and there was this Justice Dennings actually, and he came up with a principle of he came up with an explanation under what circumstances that the principle of promissory estoppel would operate. Now, this guy Mahir, he owned a particular property, and this particular property had certain buildings on it. So he was negotiating with Walton Stores. This Walton Stores was a kind of a departmental stores. That's why they call Walton Stores, and it was a huge corporation rather, and they wanted to rent out the premises of Mahir. So Mahir already had certain buildings on the premises, certain existing buildings on the premises. So when these two got together, Walton's, in the course of conversation must have said that, no, your buildings have become old and so on. So what Mahir did was he demolished some of the buildings, he demolished it to the floor, and he erected new ones. Why? He wanted to present the best to Walton's. Now, there was no formal agreement made between Walton's and Mahir, but Walton's just, in the course of discussion, in the course of verbal discussion, they kind of, expressed their willingness and the interest. When you talk to someone, sometimes you can gauge the interest of the other party. So, in the course of conversation, in the course of negotiation, Walton Stores has expressed the interest and negotiated terms with Mahir. And those terms operated in law like representations. So he relied on the negotiation terms, on the representations that was made before a formal contract was completed. What Mahir did was he acted on it and he demolished the building and started to erect a new building. But the contract was not, signed, or there was nothing on paper. There was, and in fact, Walton's were, if you go into the depths of the facts, I'm trying to just give you the overall scenario. I'm not going through the details of it. But if you go through the details, Walton Stores had a legal department, and the legal department was, normally it takes time to prepare a contract, and they were taking time to prepare the contract. But the management head and the top management kind of later on. Yes.
No, just maybe that when I left here, maybe he called me, and so I'm waiting for him.
I told you, when you enter the class, mute your mic. So Walton's, the top management, we were talking about the top management. Walton's, that is the top management told their solicitors or their lawyers to slow down the deal. They said that, okay, let's slow down. In the world of commerce, or in the commercial world, it always happens that you have better opportunities, or you might come across something else, some other kind of a deal, and so what happens is sometimes the parties can change their minds even before a contract is concluded. That. So what Walton Store's top management did was, before this lease agreement was signed, Walton was trying to inform the solicitors or the lawyers to slow down the deal while they did further investigations whether or not the transaction would be a good business, whether it would be a profitable business. But they allowed Mahir to remain under the impression that the deal would be completed. So this side, Meher was all the while thinking that the deal would be completed. So just for the benefit of Waltons, or to expedite the process, or to prove to them that the deal is worthy, what Mahir did was he demolished the existing building and erected a new one, so that so that Walton stores would be happy. Later on, what Walton stores did was they said, well, we're not interested in going ahead with the deal. So now here is already incurred expenses in demolishing of the building and erecting a new building. So he was, of course, irritated. He was angry. So he yelled at them, and then, but still they wouldn't agree to him in simple terms, and then he files a case against Walton Stores. The long story short, of course, it went to the High Court. The matter went up to the High Court. And there, this was what was observed by the court, what you can see in the inverted commas. Waltons negotiated with Mahir for the lease of property owned by Mahir. This was what was discussed. The parties understood Mahir would demolish an existing building and erect a new one, which Waltons would occupy. Agreement was reached on terms and rent. Walton's solicitors sent a draft lease to Mahir's solicitors in October, and some changes were discussed. A revised lease was then sent to Waltons by Mahir. In November, Mahir informed Waltons that demolition had commenced, and it was therefore important to conclude the lease quickly. Later that month, Waltons started to have reservations about the lease and instructed its solicitors to go slow. In January, Mahir commenced building. Later that month, when approximately 40% of building work was completed, Waltons informed Mahir it did not wish to proceed. So Mahir brought action to enforce the agreement. Now, the court held in favor of Mahir and allowed the principle of promissory estoppel to operate. Now, there was this Justice Dean who observed in this case that there was estoppel by representation, that is common law estoppel, specifically that Mahir had acted on the assumption that contract had been signed, and Walton Store was therefore stopped from denying that it had signed the document. Next, in Combe versus Combe, 1951's case. Here, it's the age-old case. KB means King's Bench. It's a famous English contract law case on promissory estoppel. Here, there was one Mr. Combe and Mrs. Of course, his wife was Mrs. Combe. They were a married couple. Now, Mr. Combe, he promised Mrs. Combe that he would pay her an annual maintenance. There was a kind of, promise between husband and wife. He said that, I will pay you annual maintenance. So their marriage eventually fell apart and they were divorced. So Mr. Combe, later on, of course, because the marriage fell apart, he was angry. So he refused to pay any maintenance that he had promised. 7 years later, Mrs. Combe, later on she was Miss Combe because she was no more Mrs. Combe. So let's call her Radhika. So this lady Radhika, once upon a time, was a wife of Mr. Combe. She brought an action against Mr. Combe to have the promise enforced. That is, she wanted the annual maintenance. So there was no consideration in exchange for the promise. And so therefore, there was no contract that was formed. So she argued the principle of promissory estoppel in the court, as she acted on the promise to her own detriment. Now here, interestingly, there was just Justice Denning. So he drew a line, or he substantiated, or rather he clarified the principle of promissory estoppel, and he said that promissory estoppel normally in this case would not be applied. Now, that was available only as a defense and not as a cause of action. He limited the application of promissory estoppel as he explained the doctrine with the aim that it did not dislodge or throw out the doctrine of consideration. I'm repeating. The principle of promissory estoppel, he says, does not dislodge or does not throw out the doctrine or cannot be pushed into oblivion or cannot be forgotten. The doctrine of consideration or the concept of consideration in contract cannot be forgotten just because we have a doctrine of promissory estoppel. But he said that a promise should not itself be a cause of action, but it can be a foundation of defensive equity. So that's why they say that promissory estoppel works on the principle of equity, that is justice, equity, and good conscience. So the principle of equity, but it does not, in contract law, undermine or throw out or dislodge or cannot push into oblivion, or the concept of consideration cannot be pushed aside at the cost of promissory estoppel. Consideration is an important factor, is an important element in contract law. What is consideration? Something that is given in exchange. So consideration, there is no consideration in this husband and wife's case. In this issue, there is no consideration. So Justice Denning said that she cannot be made entitled because, and she cannot use the promissory estoppel because consideration cannot be forgotten. However, why? Because a promise should itself not be a cause of action, but it can be a foundation for defensive equity. So what are the elements in the doctrine of promissory estoppel? There has to be a clear and a definite promise. There must be some kind of a legal relationship. The promisee should have acted upon that promise by placing reliance on the promise. And such an act should be in good faith, and it should have caused some harm, or it should have been to the detriment of the promisee. So that is, it has been unconscionable for the promiser to retract from his promise to promisee. That means the promiser should not have been in a position, or it should not be right for the promiser to retract from his promise or to go back from his promise. So a party seeking to enforce the principle of promissory estoppel must be able to establish that it has been unconscionable. That means it was not right for the promiser to retract from the promise, and that such a retraction has been to the detriment of the promisee, because the promisee has acted upon the promise. So therefore, this doctrine of promissory estoppel is kind of a judicial device, in simple terms, or to recapitulate the principle of promissory estoppel. Now this doctrine acts as a judicial device in common law legal systems, whereby a party is estopped or stopped, or in legal terms, estopped from retracting from their promise. From what? From retracting from their promise. So this is the doctrine of promissory estoppel. So I look forward to correcting your assignments on this particular topic. Examination point of view, this is an important topic.